Once I was told that all conference speeches should be started with a joke, so please let me introduce myself, because my presence among such distinguished colleagues is quite funny for me. My name is Barnaba, Rud-Chlipalski from the Rymarz, Zdort, Maruta law firm. I am an associate there, and I will be moderating today's panel with great speakers. Kane from Frankfurt, Kurnit law firm based in US. Yiannis Karamanolis from Karamanolis and Karamanolis, also law firm in Cyprus. Francesco de Rugeriis from LCA Studio Legale in Italy, one of the biggest law firms in Italy. And last but not least, Andrzej Gadkowski from the World Intellectual Property in Geneva, Switzerland. So maybe would you like to tell the audience, give a little bit hint about your connections with the video game industry and your experience in that field?
Good morning everyone, and very warm welcome to this panel. We will be discussing disputes. It's not the topic for Monday morning, but we're happy to see so many of you joining us today. We are giving with a very interesting tasks. We are all lawyers. We are all dispute resolution lawyers, and with this global phenomenon of video gaming and the blooming industry, it would be quite naive to think that disputes concerning video games will not occur. They do occur, and because the industry is blooming, the disputes might be also on the rise. So what we were supposed to, what we will be doing this morning is to discuss what are the approaches or how we can handle video gaming disputes, in particular disputes spanning multiple jurisdictions, involving different stakeholders in different countries. And me personally, I'll be talking from the perspective of an international organization and a neutral alternative dispute resolution provider, WIPO Arbitration and Mediation Center, who has tailored and specific services for time and cost efficient mechanisms allowing parties to solve video gaming disputes.
So I'm a U.S. lawyer. I've done nothing but video games for 20 years now. So I'm going to be, really just here to say how great, litigation is in the U.S. It's what everyone wants to litigate there because it's so expensive, and so for lawyers, what better thing could you think of than that? And we've actually worked on a couple of matters together, so we're going to just talk more about, realistically some of the issues and, why it may be good to sue in the U.S., why it may not be good to sue in the U.S. So hopefully we'll give you guys some ideas on, thinking through these things from a much more strategic approach.
Well, hi everyone. Thank you for the invitation, and thank you. I would also start with a joke, I think. We would like to thank the organizers for making this, making us start at 10 o'clock instead of 9, because if we started at 9, I think not even the panelists would be here. So I'm Yiannis. I'm a Cypriot and Cypriot lawyer. Similarly to Poland, there are hundreds of video game companies and tech companies in Cyprus at the moment, and Cyprus is now considered one of the most popular hubs for this kind of companies in Europe, and I believe in the whole world at this point. Fortunately for us, the market is still small, so we cannot concentrate on the video game industry exclusively, but we do, because there are many companies in Cyprus and we see these times a lot of disputes starting about involving video game companies. We have a lot of expertise, and as Sean said, we have already worked and we have already had some disputes in Cyprus already. We are quite new. We started, I think in Cyprus, video game companies started having disputes in this industry in 2019, but we have a lot of disputes, so we are here to share some insight and some practical insights about our experience in this industry. Thank you.
Hi everybody, and thanks for the organization to invite me here. I'm Francesco de Rugeriis from Italy, Milan. And together with my colleague who's not here today, Nicoletta Serrao, I co-coordinate the gaming and esports focus team in LCA Studio Legale, which is a great inheritance of the unfortunately passed Andrea Rizzi, which maybe someone of you used to know, who was a great video game lawyer in Italy. And so in Italy we have a lot of developers, definitely no very good publishers, but that's a particular feature that's helping us in working with a lot of international publishers who are looking for extremely talented developers. But that also means that sometimes things go south and you can fight about stuff. And so here I am, exactly with my colleagues, to talk about some strategic elements to take into consideration when you are litigating in Italy or Italy is at stake.
Okay then, moving swiftly to the topic itself then. My first question would be, what are legal disputes related to video games are often multi-jurisdictional, and why? Why is that so? Sean, could you answer?
Sure. I think the main point is that it's an international industry, and you have games being made by teams all over the world, published by other teams all over the world. And so, quite often there are, issues that are kind of localized as well. So we end up with a situation where you have to kind of decide which jurisdiction you want to kind of raise the issue in. There are certain jurisdictions, all kidding aside, I joked around about like suing the US. I would say the US probably has the deepest bench of law in this area. There are a lot of cases, there are a lot of decisions, in video games. So a lot of people want to sue in the US because of that. But there's also a lot of reasons why you may not be able to, or you shouldn't, and you should consider looking at other jurisdictions as well, because some of the things you may not be able to get in the US, you can get in another jurisdiction. So at least in my experience, we often will try to strategize about, are we going to sue in one place? Are we going to sue potentially in multiple places? What sort of relief can we get in one jurisdiction versus another for the client? Because, just because you get a decision in the US doesn't mean it's going to be enforceable somewhere else, or at least, even if it is going to be enforceable, it doesn't mean it's going to be easy to enforce it. So.
Yes. So, what are the biggest challenges in this regard, in terms of coming up with a whole strategy regarding multi-jurisdictional dispute? Yiannis, could you tell us a little bit more about it?
Yes. As Sean said, I think it's inevitable for these disputes to be multi-jurisdictional and have many cross-border elements. The first reason for that is, and this is actually the main challenge and the biggest challenge in every dispute that arises with video games. The first reason for that is because the production chain, it's so big in order to achieve to have the final product, the video game. So there are a lot of contractual arrangements involved, and inevitably some of them will be between foreign parties. The other issue is that the protection of IP is mostly territorial. Therefore, you will need to work with other lawyers and to have a strategy. You have to find the best effective and the cost-efficient and an effective strategy for the client. So what is important is, and the main challenge is to find out another issue before I proceed. The other issue that makes it more challenging is the power, the significant power of the platforms. All of the games, as I heard in a panel yesterday, we're not making games just for Cyprus or for US or for Poland. You want it to be available in many countries or even worldwide. Therefore, the power of the platform is significant. You want it to be available through Google Play or through the App Store. Therefore, inevitably, you will need to work with US lawyers in order to find a solution, an effective solution for the client, in order to make the remedy enforceable or convincing for the platforms. Otherwise, even if you litigate in Cyprus or in other jurisdictions, if the game is taken, if the platforms decide to take down the game, then the video company that has the game will be ruined and it's going to be a disaster. And even if you manage to litigate in a jurisdiction and you finally win in this dispute. So the challenging part is to liaise and to make a strategy with other lawyers around the world so that you find a strategy that will be effective and that will be convincing to and effective on the platforms. And the other issue that I would like to mention is to find a jurisdiction that interim relief is available immediately for the same reasons. So even if you are right and you have a very good claim, if you will need to have a litigation procedure for 3 or 5 years in order to get a final injunction, this is useless. So I think the coordination of the strategy with many lawyers around the world and the possibility and the availability of interim relief, it's the most challenging part and the most effective part in this kind of disputes.
Thank you, Yiannis. Yiannis spoke about the legal perspective, but I'm wondering right now, what are the biggest challenges for the clients, especially the challenges that the clients are usually unaware of? Francesco, do you have any thoughts on that?
Yes, I think actually that's the dark side of this part. It's like, because as lawyers we usually can understand some technicalities of different jurisdictions in terms of getting an interim proceedings fast and an interim injunction fast, or the legal expenses that you have to face. But the problem is that you have to explain that to clients, and clients that come from a specific jurisdiction most of the time, and that have certain expectations. So, for example, there are some things you have to explain by way of simplification. If you're working with a US client and is deciding for any reason whatsoever to litigate in Italy, or because it may be convenient for what he can obtain, or because the defendant is Italian or whatever, you have to explain to them that we don't have jury trials for certain things. We don't have it. So it's a very different way of strategically approach the litigation in many occasions, depending on what you're fighting on. So that's a very hard sometimes. There's like a cultural difference in explaining how a certain proceedings works. We have super paper-based proceedings in Italy, so you have to explain to them how that works and all the timings. And about timings, I think that's quite important, because Italy is notoriously a very slow jurisdiction to fight in. It's better now, but you have to explain that, because you might have clients that want to fight out of principle, for example, sometimes. That can be either the worst or the best client, depending on the best client, because, of course, if we fight out of principle, that's perfect, we're getting paid. But on the other hand, you have to make sure that it's actually the best interest to the client itself.
I always make sure that the ones that are doing it out of principle give a very large retainer, because
exactly.
principle seems to fall apart
sooner or later they fall apart, exactly when they also see how long it takes. So those are just of the few elements. Plus, another thing you have to be very aware of and explain to clients is how judges are in a certain jurisdiction. I do expect judges, for example, from States or Cyprus or other jurisdiction to be well prepared in the video game industry. I do not expect that in Italy, especially for contractual breaches. On the other hand, you might have super expert judges on IP. So you have to think of that and explain that to the client, and how that's gonna cost, how that is gonna affect their business, how long they have to wait to do something. So those are, I think, the core elements to be aware of?
As I hear it, the biggest challenge is the necessity to go to court. So, is it always necessary to go to court, Andrzej?
Well, it's good time for me to react. And first of all, I will agree. Video games are global products. Video gaming disputes are very complex, and they are blending tangible and intangible assets. There might be several IP involved, and as Yiannis said, IP rights are territorial. You would need to register them and protect in every single particular jurisdiction. And some video gaming disputes will be a mix of copyright dispute. For example, the game story, music use in the video game product, design, packaging of the video game can be a patent dispute. It's also can be a purely contractual dispute. There are so many contracts involved: distribution, advertising, publishing, with entities or stakeholders from all around the world. So, given this complexity of the disputes and also stakeholders, multiple stakeholders from several jurisdictions, I would add to all the considerations that were given by my colleagues. One thing to consider by lawyers and the clients is whether it wouldn't be most suitable to file a dispute to alternative dispute resolution, to one of the alternative dispute resolution options, which are particularly effective and efficient in the context of multi-jurisdictional disputes. Parties to multi-jurisdictional disputes can decide to suspend all the court proceedings pending in 5, 10, or 20 jurisdictions on several continents, and to submit one dispute to mediation or arbitration. And the result of one proceedings, be it mediation, arbitration, or expert determination, will terminate all the pending disputes. And in our case, at the WIPO Arbitration and Mediation Center, we've seen a lot of, we have administered a lot of multi-jurisdictional disputes. And if I may, just one example that illustrates well how ADR can be efficient in the context of multi-jurisdictional disputes. We had a dispute between two multinational companies involved in a patent disputes for consumer good products. The dispute was pending in 4 or 5 European jurisdictions for over 2 years. That is, both companies had lawyers hired in each of the jurisdictions, defending their rights and waiting for the outcome, the final outcome of the jurisdiction, which also will depend on the rounds of appeals. It can be a long process. And remember, IP rights are territorial. Not all jurisdictions will tackle the same issue in the same manner. So you can have the same dispute in different jurisdictions, but have different outcomes of it at different times. So being involved for over 2 years in these disputes, the parties decided to submit it to arbitration. They designed a submission agreement, a very detailed submission agreement, when they were very precise. The parties wanted exactly what they want. They want to terminate all the pending disputes in different jurisdictions. They want to have one result. They wanted to have a 3-member arbitral tribunal making a decision. The parties were also very, very detailed in terms of the schedule of the proceedings, which was based on patent litigation in Germany, because Germany was the main jurisdiction for their dispute. It took them 5 months. From the moment the request for arbitration was filed till the moment the tribunal rendered a final, binding, and enforceable decision. Within 5 months, they got the result. And all the pending court litigations in 4 or 5 European jurisdictions were terminated. So that's how time and also cost efficient ADR can be. That's only one example that I'm sharing right now. I hope that we will have time to say a few more things on other cases. Here I mentioned arbitration. Arbitration is one of ADR options, and arbitration is or can be compared to private court litigation. You're submitting a dispute to a tribunal that will render a final and binding decision, but it's only one of the ADR options that are way more a more flexible mediation option, where parties will appoint mediator who will assist them to find the solution of their problem. There is also expert determination and other ADR mechanisms.
I think Yiannis wanted to make a comment.
Yes, on that, yes, of course, I am a litigator and also an arbitrator, and I usually advise clients, of course, to include arbitration and other ADR provisions in their contracts. The problem with arbitration is that due to the consensual nature of arbitration, there are some disputes, it's only applicable on the contractual disputes that arise in this industry. So, for example, if you have contracts, a licensing agreement, if you have non-disclosures agreement with your developers, with your employees, with your other people, independent contractors, if you have employment agreements, or in any agreement you can include arbitration about royalties, for example, or audit provisions, then you can of course rely to arbitration or to what I usually do, to expert determination, which is even faster, I think, and it's more difficult to be reviewed. It's binding, it's final. So about contractual disputes, yes, we can include ADR. The problem is that there are many disputes in this industry that come up when the parties to this dispute have no relationship between them. For example, if you have a successful game, inevitably there will be a dispute and you will need to go to court because there is no contractual relationship with the company that will make a clone of your game. So arbitration is it's a good thing. I think it's very efficient and expedient proceedings for dispute resolution. However, sometimes it's even more expensive than litigation. And sometimes, and I don't know if it's good to say that, sometimes the strategy is that you do not need an expedient resolution. It depends who you represent. For example, it doesn't make any sense if I'm a big company and I can obtain an injunction against the other party within 2 or 3 days, and then I don't care if the litigation will take 3 or 5 years. So these are some considerations that maybe arbitration is not a very good solution. But generally, we are of course in favor of arbitration, and we advise clients to consider expert determination provisions and other ADR solutions in their contracts.
Well, it's interesting because we've seen a couple of cases. You know, you were mentioning like clones where the parties don't have a relationship, and obviously, if someone wants to go to arbitration, wants to use ADR, they can if both parties agree, even if it's a claim that there's no clause about. But we've seen some cases where parties try to, you know, bring in an arbitration clause from, say, like a platform. So they have two games that are on, you know, the apps, you know, one of the app stores, and one of them is arguably infringing the other, and so the parties try to like, well, since you're on the app store and there's an arbitration provision on the app store, we can bring an arbitration against you, which really, it's not what those agreements are between. It's usually between the app store and the individual. But we've seen companies try to do that sort of thing so that they can kind of make use of an arbitration provision. It hasn't always been successful, but sometimes people try it.
Apart from submitting the matter to arbitration, are there any other tools which might help the client secure their interests in the whole region? For example, the whole EU. Francesco, yes, please.
Well, yes. For all the European Union, you can have pan-European injunctions, which are something you can be aware of, and actually they become important when you don't have a relationship from the beginning, because you have a copycat or a counterfeiting or something, especially for designs and for trademarks. So usually in Europe, this is a strategy that starts from the top. You are designing your game, you're making your game, And then you start realizing together with a professional, okay, what can I actually file for registration as an IP asset on this video game? Just to be sure I have more arrows to shoot with my bow. So usually designs and trademarks are a good thing, especially if you want to go international, and that's something that many developers want to do. So you file for a European Union trademark or a European Union designs. Then, if something bad happens, you have two choices. Either you fight home, because maybe the counterfeiting has effects in your home, but the counterfeiter is not from your country. So for example, if the counterfeiter is not Italian, but is abroad, that's great. You can fight him and start a litigation in his country. In that case, you can ask to a specific court, which you have to designate with certain formalities, for a pan-European injunction. So that means that when you get that injunction, that can be faster or not, it can have a pan-European effects. So that works in all the territory. Of course, this is court speaking, because if you have the platform at stake, you can have even a more disruptive effect, but that's not with a perfect balanced system. Let's take to the court. The same happens with trademarks. On the other hand, you can, if you want that kind of decision, you have to think about I am not going to have the litigation in my jurisdiction, which you could have if there is proof that the counterfeiting also happened in your jurisdiction. So the easiest way is to, for example, physical distribution, buying a game and having a receipt. You have the receipt as evidence that that counterfeiting game is sold in your country too, so you can fight at home. But in that case, you cannot have the pan-European jurisdiction. At least in Italy, it works that way. So this is something you have to think about strategically from the top. When you have like something you cannot go to arbitration because you're not fighting with someone that you had a relationship before in a contracted situation, and it's very hard to wanting an arbitration later on, especially with counterfeiters is very hard sometimes. Also for, I would say, a psychological element of I don't feel confident going to a private court. There is still some situation about that. We're trying to fight that approach, of course, but that's more of a business-minded and business-oriented thing. But also thinking where you are designing your strategy, if you want a broader or a narrower effect, depending also on what you want to obtain, because sometimes litigation are started just to push people to settle, so just to put pressure on them.
What we are talking here right now is like those big, complex, cross-border litigation projects, right? So my question right now is, in this regard, how important is the cooperation between lawyers from different jurisdictions? How do you organize such a project? How do you manage them? And how does that kind of a cooperation normally look like? Sean?
So, I mean, I think it's really important when you're dealing with something like that, and you're dealing with either local counsel in some place, to really coordinate with them, because, you know, as I said earlier, there are certain things that you might be able to get in one jurisdiction that you can't get in another. You know, I don't always think that, you know, my jurisdiction is the best jurisdiction and we should always file things. I mean, we literally had a case where, you know, I think our client wanted us to file in the U.S., and basically we kind of talked them out of it. We're like, you know, right now it makes more sense to file in Cyprus, you know, and the result they're going to get from that jurisdiction is better than the result they might get in the U.S. And so I think it's sometimes not being, you know, some people think they're the master of the world and their jurisdiction is the best one and you should file there. But I think you need to understand, like, there are times where it makes a lot more sense to not be the person kind of running it and work with a local counsel in a jurisdiction where your client can get a result that's more beneficial to them. You know, like, we could have filed in the U.S., but we never would have gotten the type of result that Yiannis got in Cyprus on behalf of the client.
Would you like to share any, like, your recent experience?
Well,
with the confidentiality, of course, but...
Yes, we will not mention any confidential information, just some general comments. Well, we see the types of cases we see now in Cyprus a lot is inevitably we see some breach of contract, and I will come to what Sean, our experience with Sean and his firm. We see breach of contract. As I said, there are a lot of contractual arrangements in the process of the video games, of protecting the video games and making it available to the public. So we see this kind of disputes about royalties. We see companies claiming that another video game company is infringing their IP rights. And coming to our experience with Sean's firm is that we had a case where there are a lot of false allegations about cloning. So what big companies usually do is to harass and to bully actually smaller studios in order to take them out of the market. We see that a lot. So what they do, big video game companies, they are trying to make allegations of infringement while there is no infringement, or while there is no protectable copyright in their game because of prior art or because of other situations that are not protectable. So they make complaints, false complaints to the platforms, and we come again to the issue, the significant power of the platforms. So they make allegations, they don't go to court, they make complaints to the platform, they manage to take down the games from, let's say, Google Play, and then they are trying to do the same with Apple Store. So we had a case where a big video game company wanted to bully our client. They managed to file complaints in to Google, and they managed to take down the game from Google Play. And they were doing the same thing with App Store. So what we decided to do is to file the claimant. Our client was a Cypriot company. So we filed a claim in Cyprus for a declaration of non-infringement of copyright. And in the context of this claim, before going to the context, we included Apple as a necessary defendant to this claim. And we managed to obtain within a couple of days an injunction against both the defendant and Apple, ordering them not to take down the game. And even though Apple and Google, they're US companies, I think Google is also an Irish company, and they needed, the injunction was not directly enforceable on Apple. Usually the platforms respect injunctions and other orders emanating from a court, and especially from a court of a European court. Therefore, with this kind of strategy, we managed to secure that the game is still on App Store. Because without the injunction, without getting the injunction, even if we manage at the end of the day to obtain an order, a declaration of non-infringement, it will be a disaster for the client. Because in the meantime, their game will be down from Google Play and from the App Store. So it's going to be a disaster. So we needed an injunction, and this is actually, so it's important to find jurisdiction where this kind of injunction will be available.
Something. This story actually made me think about something, that is the fact that finally the platforms are acknowledging the power they actually have. Because of course, when we think of the most efficient way to remove a counterfeiter, we think of notice and takedown. The perfectly private, works on platform, few moments, even few hours sometimes, you can have everything taken down. But we have to think that that is an outcome that in court would come after an evaluation of a judge, even a prima facie evaluation, but of a judge based on a certain amount of degree of evidence and periculum memora. So actually, I'm actually facing an irreparable harm. So you have to balance the situation in a contradictory term, which notice and takedown doesn't take into considerations. So of course, if you are the stronger the stronger man in the situation, you're the one with the power, with that, having a super fast notice and takedown system is extremely efficient, but on the other hand, you have to think of the other side of the you are facing on, because that's extremely easy to bend it to abusive behaviors and boycotts or other bullying situation. We can raise something different. So a few years ago, I think that the platform went easier in granting this sort of notice and takedown decision and say, okay, just remove it and then you let me know. Now they want at least a provision on that. So this is kind of becoming a cooperating, circling situation where if you have a good injunction that you obtained from a good jurisdiction, as Yiannis and Sean did in Cyprus in this kind of case, then you can have the notice and takedown on actually a stronger basis. And the fact that the platform wants that kind of basis is because they do not want to be associated with any sort of abusive situation. And I think this is a great result we are obtaining in the last 5 or 6 years, because 6 or 7 years ago, this wasn't happening. You could actually see something going down very easily and not always with reasons.
You know, it's interesting, and you talk about the power of the platform. Like, we've seen a bunch of cases where, you know, US-based lawyers are representing international entities against other international entities, and they're trying to file suit in the US, specifically in California, because that's where the platforms are. And they're basically taking the position, well, if your game is on Google Play or it's on the Apple Store, then they have jurisdiction over you in California, which, again, you know, there might be better jurisdictions, internationally to get the results you want. But there are certain lawyers that are trying this tactic with some degrees of success. Like, my firm's been fairly successful in fighting those sort of things on jurisdictional grounds on behalf of our clients, because, you know, none of the parties really are in the U.S. And we've argued that just because they're on the platform doesn't mean that, you know, they have jurisdiction. And, you know, the analysis there sometimes gets into, like, what are they actually doing in the U.S.? Like, are they pitching U.S. individuals? Are they pitching California individuals? Are they marketing towards them? Or they just have a game that's available internationally? And sometimes the analysis really comes down to whether or not they're, you know, really focusing on the U.S. territories. And if they are, there may be jurisdiction. If they're not, then, you know, we can go back. And I mean, it's great what you said, the platform. These days, for the most part, if you're responsive to the platforms, like if someone sends, you know, a takedown notice and you're responsive to it, they won't act. Because they're kind of like, okay, now you guys are both talking, you deal with it. Like, take it to court if you need to or not. Tell us what happens. And 9 times out of 10, that's the case. Like, you know, we have seen a couple times where, you know, the platforms have been a little bit more willing to potentially take something down, even when both parties are arguing back and forth that there is or isn't infringement. But for the most part, if you respond, they kind of take the position like, well, we've done what we need to do, and we're hands off.
And adding up to what Sean said, even though there is no jurisdiction, even if there is no jurisdiction because of the platforms, we advise clients during their interaction with and even if we decide to go to Cyprus, for example, or to another jurisdiction for relief before the court, we always advise clients, as long as the platforms are involved, even if there is no jurisdiction of the US court, they have to take advice from the US lawyers, because in the process of the taking down notice and the counter notices, you may submit to the jurisdiction of the US. So you need to be careful, and I come back to the strategy, to the overall strategy. It's important to have a coordination and to agree on the strategy with lawyers from many jurisdictions, including the US, because there are many pitfalls, and you may end up submitting to the US jurisdiction without, even if you decided the strategy not to litigate before the US courts.
Yeah, that's a really great point that you brought up, because, you know, sometimes in the US, and again, for those who don't know, like what we're talking about takedown, there's a thing called the DMCA, Digital Millennium Copyright Act in the US, which allows you to send a notice to a party that might be posting something that you claim infringes your copyright, and they have to, there's a specific set of actions they have to take. And once a claim like that is submitted, you have to send in like a counter notice. Part of some of those notices, the official way you're supposed to do it is actually to kind of accept jurisdiction. So, you know, we've been really cognizant in some cases to send a responsive notice that doesn't actually do that, doesn't actually accept the jurisdiction, because we're basically saying that, well, there isn't jurisdiction here, but there also isn't infringement. And so, you know, we're trying to send something to push off the platform, but without basically lining up our client to have to deal with a litigation in the US when there may not be a reason for it to be in the US. I mean, again, you know, we make money if it's in the US, that's wonderful, but there are so many times where we're telling the client, like, you don't, like, there's no reason to do this, or there's no reason to do this here. It may be better and less expensive because in the US it's just crazy expensive to litigate. But it may be better and less expensive to bring the case somewhere else.
As I understand it, the first stance of the battle is obtaining the injunction, right? That's one of the most important aspects of any litigation proceedings with regards to the game. So my question to Andrzej would be whether an arbitrational tribunal can issue interim injunction, and whether such injunction relief are respected by the biggest platform holders operating globally.
Yes, the tribunal can issue interim relief injunctions, just as national courts can do it. It will depend on the rules of the institution. For example, WIPO arbitration rules and WIPO exploited arbitration rules provide for such a possibility or power of the tribunal, and this power is in parallel with the power of national courts based on the place of arbitration. So parties can seek such a remedy from arbitral tribunals and from national courts. In just commenting on what my colleagues have said, of course, not all video gaming disputes are well suited for ADR. Yeah, in some cases, litigation is still the best forum to solve a problem, and we were giving with some examples of counterfeiting. Of course, if the parties or one of the parties is acting in bad faith, there is little room for a settlement within the mediation. All ADR procedures are consensual. All parties to a dispute will have to agree to submit it to mediation, arbitration, expert determination. If there is no agreement between all the parties, the dispute will end up within a court in a given jurisdiction. But still, ADR offers many advantages, and in the context of video gaming disputes, and it's not replying to your question, Barnaba, but I wanted to just take 1 minute of your time. ADR very often is the best forum for all kind of disputes, including video gaming disputes. First of all, because of its flexibility, it leaves parties greater control over the process, how the process is structured, confidentiality, and also, and maybe most importantly, if parties would opt for arbitration, mediation, or expert determination, they would be the one selecting the arbitrator, mediator, or expert with a particular knowledge of the industry, with some technical background, with negotiation skills, and the knowledge of a particular substantive law. Not all jurisdictions are equipped with courts that are, first of all, courts specialized in IP, and having judges who know the video gaming industry. Some disputes are very technical, and if you don't want to spend too much money and time explaining to a judge in particular jurisdiction what is this dispute is about, what are the issues involved with patents or copyright or software, and other commercial issues.
Or royalties,
Royalties,
audit provisions of royalties.
course, valuating the whole project or video gaming project. When you submit a dispute to ADR, you will be the one selecting an arbitrator, mediator, or an expert with a particular expertise. And this is my last comment. The WIPO Arbitration and Mediation Center has been on the market for 30 years, and our big know-how is the list of over 2,200 specialists from all around the world, at least one of them sitting in this room now, if not more. I don't see all the faces here, whom we propose as candidates in the dispute. So when there is a video gaming dispute that is submitted by parties, let's say from Singapore, Mexico, US, and Poland, and the parties will be looking for someone who has a particular knowledge of a copyright law in a given jurisdiction, the video gaming industry, a bit of IP valuation as well, we will have someone who will present as not someone. Normally we present 3 to 5 candidates, and from that list the parties will select the most suitable arbitrator or mediator. What is of utmost importance in efficiently and effectively solving a dispute is to have someone, arbitrator, mediator, or judge, who knows the industry, and who understands the problem.
And from what I remember from the yesterday's panel, that's the biggest challenge actually in terms of disputes in video games. The judges are simply, the cases are very, very complex, and usually normal judges are not used to them.
If I may add a point to what Andrzej said, and I will share a practical example, and I'm sure you will be familiar with similar cases, where we had the same case and we resorted to arbitration because we wanted specialized someone with expertise to decide, and with the same facts. In another case, we didn't want to go to arbitration, but we wanted to go to the court. I'm referring to disputes similar to the case with The Witcher and Sapkowski had in Poland with The Witcher. So we had a case where the previous owner of the IP of a very successful game transferred the IP rights for a very small amount of money. So it was a foreign client, and the transferee, the new owner of the IP rights was a Cypriot entity. So we decided to file a claim for fair and appropriate remuneration. In that case, we filed the claim against the company, the new owner of the IP. In the context of this claim, we applied for interim injunction, and we asked the court to take down the game and to prohibit the distribution of the game. It was very draconian order, and while this was pending, this resulted in a very good settlement for our client. Now, and we see this kind of disputes coming up a lot in Cyprus. Now, with the same facts, we wanted to add the director of the company, the new owner, the company who owned the IP rights. And we were very lucky that the contractual arrangements between the parties did not provide for arbitration, but only for litigation before the courts, because it will be impossible to add other parties to a dispute before an arbitrator without the consent of that party. And usually when we allege fraud, because our allegation was that the director personally defrauded our client and made him sign this agreement. So when fraud is involved, usually there's no room for arbitration unless the other side agrees, of course. And because of the consensual nature of arbitration, the third party, the director of the company, could not be included. Therefore, we filed a claim before the court, and we again asked for an injunction against both the director of the company and the company, the new owner of the IP rights. And again, this resulted in a very good settlement.
Just to give you a perfect opposite example about in a situation, I wished I had an arbitration clause in my agreement, and we did not. There was this case where when the agreement was being drafted, we suggested to have a WIPO ADR clause. Or even another ADR clause. We always suggest WIPO because we have video games there and everything, and the client, who was a video game German investment fund, said, no, we don't want it because that might be too expensive. We are scared of that. Everything is going to be just fine. Yeah, those are the famous last words. Of course, nothing was fine eventually. We have to start this litigation. We started in Italy, so good for us. Italian law, Italian jurisdiction. Nothing could go wrong. Yeah, right. As I was saying before, for contractual breaches, sometimes Italian judges cannot be the best choice, whilst on the other hand, for IP issues, they could be extremely amazing. So of course, this time it was contractual element. What happened? After 1.5 years of litigations, 2 hearings and 4 briefs, eventually the judge issued an order of translating all the documents in Italian. All the agreements, all the exchange of correspondence, all the advertising, all the evidence from both parties had to be translated in Italian. Please just consider that we are not fools. We already translated all the elements that were relevant for the decision of the case. So if you are fighting over 6 or 7 clauses, you already translated all of them, and all the core parts, both of the parties did the same very amazing job. Yet the court decided, no, I want everything translated, which is quite unorthodox in Italy, because usually judges know English. But on the other hand, for a video game cases, this is the first time in almost 10 years of my career and in 20 of my partner at home. It's like, that's never happened. It's like, what kind of industry did you bring to the firm? That this never happened. And the client wasn't happy because translators costs money, and of course if the lawyers translate, it's even way more expensive. So I said, that's why I would have loved to have an ADR clause there, because that would have never happened in that case, and you could have fought based on Italian law the same. So this is just a few things to think about when you draft agreements, to prepare psychologically to what could happen and what could go wrong.
Francesco, what was the amount in dispute in this case? I'll tell you how much it would cost, yeah? And how fast you will get the result?
I would say 700,000 euros.
700,000 euros. In that case, WIPO expedited arbitration would cost you the admin fee, because we are not for-profit organization. Our mandate, we are part of WIPO, is to promote IP, so we have very discounted fees. I think in that case, the administration fee would be $3,000 and, of course, the result you would get on average within 6 or 7 months, you would have an arbitrator speaking Italian, German, and English, because we have such people specialized in video gaming industry, and his or her fee, if you would opt for expedite arbitration, because that's the biggest chunk of money that you need to pay the arbitrators. Yeah, judges you don't need to pay, but the arbitrators you need to pay.
You pay.
Oh yeah. You pay. But in this case, with the amount in dispute of 700,000, well, I think that you would pay 20,000 to the arbitrator. So 20,000 plus 1,500 or 3,000 of fees. Yeah, it would be.
Yiannis,
short
comment, please.
Yeah, of course, Andrzej, you are talking about WIPO arbitration, because if we make it an LCAA arbitration, then we are close to $1 million.
well, that's the message I'm trying to convey. The WIPO Arbitration and Mediation Center was established to help to promote ADR. We are part of the UN system, specialized agency of the UN, that mandate is to promote the development, balanced development of IP. And I would encourage all of you to try it, to try ADR. I don't know how many of you already been involved in ADR, arbitration or mediation.
Yeah, I mean, we have a couple of minutes late, so that might be a good time for a short Q&A session. Are there any questions from the audience, maybe regarding your experience with arbitration or any other forms of ADR?
Hello. I'm not going to ask you for the arbitration, but something that Yiannis and Sean said. First of all, thank you for sharing these practical insights. Okay, you were successful in the takedown notice, or they were not successful in the takedown notice, and you managed to succeed defending your client's position. Would you go further and file a counterclaim, for example, because they acted in bad faith, and file for some claim for damages?
Probably not in the U.S. because, for one, proving damages in a situation like that is going to be somewhat difficult. And the cost involved in filing a countersuit or what. I mean, if they filed a suit, we're gonna counter with something. But if we kind of won at the platform level, we probably would not go much further because it just the cost involved, the time, it's going to be excessive, and unless you can demonstrate damages of a really high degree, it just isn't worth the fight. I mean, I'm the litigator that tells so many clients this is not worth fighting because you're going to have a Pyrrhic victory. We're going to win, and you're never going to be able to collect, or it's going to cost more. Like the U.S. system is not a system where the loser pays the winner's legal fees, and so you end up winning. You're still going to pay your legal fees. You may or may not be able to collect against a party, and it just quite often it's just not worth it for the client.
Well, actually, I will tell you what we did. It depends whether you can demonstrate damage. So if they are not successful in taking down the game, and you apply for a declaration of non-infringement to prevent them from doing so, there are no damages. So you just apply for a declaratory judgment and declaratory order that there is no infringement of copyright, so that you use it and to prevent them from complaining to the platforms and taking down the game. Now, most of the times, they usually manage to take down your game from one of the platforms, and we had an instance where they managed to take down the game from Google Play, and they were doing the same complaints to Apple. So in that case, in addition to the declaration of non-infringement, we filed also for damages because of their action to take down the game and what we lost because the game was not available at Google Play. So we filed also for damages. Of course, you need to prove in Cyprus, you need to prove the damages in order to recover anything. You need to prove how much damage you sustained. And at the same time, we obtain a declaration of non-infringement so that we prevent them from doing the same from Apple. But to answer your question, yeah, it depends. If they manage to take it down, then we file also for damages because of that, yes.
Are there any other questions?
And just to add that in Cyprus, the principle is that the loser pays for the legal fees. But the problem is that you cannot obtain, maybe you will not be able to recover all of your legal fees. It depends what an arrangement you had with your lawyers. But the basic fees for the court proceedings may be recouped from the losing party.
And on my side, and I'll be very brief, something I didn't mention, I should have started with. These days, ADR proceedings are conducted almost entirely online. So you can be developing your video games or contracting with other parties and at the same time participating in a mediation meeting, in a remote mediation meeting with a mediator based in Geneva, the other counterparty based in Mexico and Tanzania, and solve your issue within hours. Yeah? I should have spent some more time on advocating for mediation, but because it's a very efficient way of resolving disputes. 7 out of 10 disputes submitted to WIPO mediation settle, and 1 day of mediation meeting is enough for the parties to reach out, to reach the settlement. And for any of you who would be interested to hear more about ADR, please do not hesitate to to invite me for a coffee or cake after this presentation. Thank you very much.
And I think we just run out of time. So many thanks to our experts today.
Let's give a round of applause.